business organizations, corporate derivative suits, lawsuits brought by shareholders on behalf of the corporation. A shareholder has a right to initiate a lawsuit belonging to the corporation. These are known as derivative suits and are often brought against the corporation's CEO or board of directors. The CEO would be unlikely to have the corporation bring the lawsuit against himself, so the shareholders often have to take matters into their own hands and bring the suit on the corporation's behalf. In such a derivative suit, this shareholder would be the nominal plaintiff, the CEO would be the defendant, but the corporation must be joined in the suit as defendant. All shareholders at the time of injury have standing to bring a derivative suit. A large shareholding is not necessary, but the shareholder loses standing if she sells her shares before the suit is completed. Compensation and other monies recovered in a derivative suit go to the corporation, not the shareholders. However, the lawyers bringing the suit often profit from the contingency fees. In distinguishing a direct action from a derivative action, a direct action involves injury to the shareholder directly. A direct suit is brought by a shareholder on her own behalf or as a class action involving all shareholders. Suits to recover dividends and to examine corporate books and records are examples of direct actions brought by shareholders. A derivative suit, on the other hand, is intended to remedy injury to the corporation and is brought on behalf of the corporation, not any individual or group of directors. A suit brought by a shareholder to remedy breach of fiduciary duty by the CEO is a common example of a derivative suit. Derivative suits are heard under the equitable powers of the court, so equitable defenses are available to the defendant. Equitable defenses include unclean hands. The plaintiff seeking equitable powers of the court must have acted fairly, without fraud or deceit as to the controversy in issue. If the plaintiff was sleeping on her rights, and the courts deemed there was unreasonable delay in bringing the suit, the case can be dismissed on grounds of latches. Estoppel is another equitable defense. Estoppel applies when the defendant reasonably relied on the plaintiff's position before the plaintiff flip-flopped and changed his position. Certain controls are in place to prevent the shareholders bringing frivolous derivative lawsuits. The shareholder plaintiff must make good faith efforts to have the corporation bring action itself before bringing the derivative suit. In some states, this involves the shareholder first making a demand on the board of directors to bring suit. In Delaware, a special litigation committee is appointed by the board of directors to consider the case. If the litigation committee decides not to have the corporation pursue the suit, and has good faith, independence, and a reasonable basis for its decision, the court will accept the committee's decision and dismiss the case.